Hello, Midas Mighty. Harry Litman of Talking Feds here. It's a week that really leaves no room for anything other than ruminations about the tragedies in Texas. And I was going to talk about gun control measures, but the sad fact is, after this morning, when Republicans refused to even permit discussion about a national terrorism law, much less any kind of reasonable gun safety measures. Basically, your Congress is assured to do nothing in the wake of this terrible tragedy, the 288th, I think, assault shooting in the United States this year. Nevertheless, I wanted to discuss something tangentially related and important and current, which is the Supreme Court case of New York State Rifle and Pistol Association versus Bruen, which is going to be coming out soon. It was argued some months ago, and it will be one of the flurry of cases in the next month, and one of the more important ones. And the way the court decides it will really have something to say about future assault shootings. The case of Bruen concerns a concealed carry law in New York, which gives people in New York the right to have a concealed permit, a permit to carry a concealed gun, but requires them to show some kind of particular cause. And that's what's been challenged here. A couple people who New York said, you haven't really passed muster in what we're looking for, sued, and they went all the way to the Supreme Court, where they're arguing, look, this is a constitutional right we're talking about, and if it's subject to the discretion and vagaries of local administrators, that makes it not a right anymore. That's their basic take, though we have an argument, as we do, say, in the abortion case of Dobbs, about history and tradition. But here it kind of cuts the other way, because there's a long tradition, especially since about the 1920s, of laws just like this in states all around the country. And so here, Justice Sotomayor, for example, at oral argument said, how do I get around the fact that states have been doing this forever? And the answer by Paul Clement, who represents the people who want the permit and is maybe the most prominent advocate these days in the Supreme Court, is that you can't really look at history now. You have to really look at the text of the Second Amendment. That text provides a right to carry, and if it can be just defeated by the discretion of local officials, it's not much of a right. The new conservative majority and Chief Justice Roberts, so 6 people, seem pretty receptive to that argument, and it's likely that the New York law will be struck down. But what really matters now, in the wake of Texas, is what will they say about how you analyze Second Amendment challenges, and what will that have to say about incidents like Texas. They're obviously aware of the issue after the news, and even at oral argument, there's a whole question about so-called sensitive places like airports and universities. And they may well speak to that in the opinion and kind of cleave it off. Justice Kavanaugh was saying, we don't have to talk about sensitive places. We'll leave that for another day. So it's important in and of itself. It'll be the most important holding that the court has made on the Second Amendment since the Heller case, basically recognizing an individual right. And by the way, it's one of a sort of stupefying number of cases, I think 33, that the court is going to decide in the coming month, and several of them will be blockbusters. So the thing to look for is not whether they strike down the law, they probably will, but what they will say and how what they say bears on questions like a state's ability to regulate the possession of assault rifles of the sort that the shooter in Texas carried into the school to mow down some 18 students in second and third grades. All right, so that's the story on the Bruen case. Harry Litman of Talking Feds. We now have our own YouTube channel, which you can go onto YouTube, put in Talking Feds, and find quickly. And until next week, you mighty Midas, talk to you later.